A guy tried talking himself out of jail time for a probation violation. In the process, he admitted to crashing his car while high on meth. He wasn't even charged with drug use. He just admitted to a DUI. Needless to say, a few days later I saw the defense attorney on the elevator and he admitted that it may have been a bad move to let the defendant take the lead on his statements. Yay, no shit. While I get it looks bad you lost a trial or whatever, but wouldn't you be happy he sealed his fate himself? He had sealed his fate when he told the arresting office, "Fuck you, fuck probation, fuck the judge. It's my first violation on this charge. They'll just give me a slap on the wrist and I'll be out in a week." The truth is, I was going to give him a slap on the wrist until the cop called me to snitch on the guy about his opinion of being put back on probation. When he admitted to the DUI despite being charged for neither the crash or his drug use, it was just the cherry on top. As a defense attorney, he was fucked to begin with, but he still could have made the argument that he was still high from the painkillers he received at the hospital when he said those things. By admitting to a DUI and using meth, he removed all doubt that he can be trusted back on probation, regardless of his statements to the cop. It could have been the difference between a year in jail or full imposition of his initial sentence. He was 4 months from being done with probation, but he ended up with multiple years in jail and a note in his file regarding his statements about being on probation. A short one. The judge recused himself from a criminal case, publicly stating that he knew the defendant and he was a son of a bitch and guilty as hell. My brother was on a jury back in the days of MySpace. She had been hit by a big rig during foggy weather. She was suing for a back injury. The last day of the trial they asked her if she has a MySpace account and brought up her site for the jury to see. I think all profiles were open then. There's a picture of her dancing on the hood of a car and right next to it is a text exchange of her saying that she shouldn't go out too much because her lawyer says that she has to look injured. Needless to say, she lost that case. A judge I worked for once oversaw a trial where a woman claimed to have been so badly maimed by a boob job that she could bear to go out in public. The case had been going for 3 years to get to the trial. On cross-examination, the defense attorney for the woman's doctor spent 2 hours reading every one of the woman's tweets since the surgery allowed. Brought in blown-up pics of the woman's posts of her in a bikini in Aruba and out at the bars for ladies' night in mini skirts and low-cut shirts. On a break, the woman ran out of the courtroom crying. 20 minutes later, her lawyer came back in and informed the judge she was dropping the case. A funny historical one here. Marshal Ney is on trial for treason after Napoleon gets overthrown for the second time. His lawyer desperately tries to save the marshal's life with an unusual take on things due to a border change. Marshal Ney's hometown was, at the time of the trial, in Prussia. Therefore, argued a lawyer, Marshal Ney was not technically French and accordingly could not be guilty of treason. Marshal Ney disagreed and shouted out to the court, "I'm French, and I will remain French." He was subsequently found guilty and sentenced to death. This also has a double whammy with badass last words. He asked for and was given permission to lead his own firing squad. His last words to them were, "Soldiers, when I give the command to fire, fire straight at my heart. Wait for the order. It will be my last to you. I protest against my condemnation. I have fought 100 battles for France and not one against her. Soldiers, fire. Talk about a way to die." I represent school districts. One of my clients has a farm that is used to teach agricultural science to the students. The manager of the farm decides to brutally euthanize a ton of chickens in full view of a group of elementary school students. Sometimes, farms have to euthanize chickens. That wasn't the problem. The problem was that he was whacking the chickens over the head with a hammer. And he had to whack each chicken like 5 to 6 times before they died, because he's apparently some kind of psychopath. The poor chickens were not dying. That didn't deter him. If one refused to die, he'd just toss the chicken on the ground and try again with another one. But the birds were all getting horrifically damaged, so they were flapping in circles on the ground, or walking with terrible, stuttering limps, or screaming. One of the kids recorded it, and Jesus Christ, it was awful to watch. So, I recommended the school district fire him immediately because holy hell, he sued for gender discrimination. I once attended oral arguments for US Court of Appeals for the Second Circuit. It's pretty much the big time. I watched a lawyer argue that his client received what's known as ineffective assistance of counsel at the trial from which she was appealing. The attorney, however, was not doing a very good job during oral arguments. So, at one point one of the judges on the panel leans forward and asks him, "Counselor, are you currently providing ineffective assistance of counsel?" Imagine getting that kind of burn from a judge in Second Circuit appeals. Do you just turn in your law degree and become a homesteader? Not a legal professional, but I do have a good story on this topic. 15 or so years ago, my dad was the manager of a small hotel. One of the semi-regular customers was this big Samoan dude who booked in for a day at a time, always had a few visitors, and always paid in cash in a 1-to-1 conversion with American dollars, highly unusual in Australia. Dad always said he was a great customer, very friendly with the staff, never gave anyone any problems, and always had a bit of a chat when he checked in. One day a couple of detectives rocked up and asked to speak to my dad. They showed him a photo of the aforementioned customer and asked if he was currently staying in the hotel. Dad confirmed that he was, and in a matter of minutes a small contingent of cops arrived, stormed the room, and escorted the guy away in handcuffs. Turns out the guy was a pretty major drug dealer and was wanted in a couple of states. Cut to the court date quite some time later. My dad is in the witness stand, and, for whatever reason, the defense is trying to make out like my dad didn't know the defendant and had never seen him before. Obviously my dad insisted that he did in fact know the defendant, but that line persisted from the defense. As my dad left the witness box, he walked past the defendant and said, "Hi Barry," to which Barry enthusiastically replied, "Hi Jason, how are you?" While I'm sure this wasn't the only thing that counted against him in the case, it certainly can't have helped. He ended up getting quite a few years in jail. My father is an attorney and he always had a story for us when we'd ask him this question. He tells it way better than I do, but I'll give it a shot. Some dude was allegedly smashing a wall with a sledgehammer with others in order to break into a private property. The cops rolled up and has the only one to get caught. Fast forward a few months and this guy's in court. Apparently a cop says something about how the defendant was the only one caught, but there were 2 other men who fled on foot and couldn't be apprehended. My father's client's face lights up in an aha moment and immediately tells the judge, "Not true, there were 4 of us." I guess he thought, if he could disprove someone, that the said he'd be let go. Safe to say he was found guilty of vandalism. My father says the judge just kind of sighed and told my father it would be a good idea to keep his client quiet. I'm a bankruptcy paralegal. I used to work for a Chapter 13 trustee who told me this story. A debtor who had filed a Chapter 7 bankruptcy was going through the normal questions at his 341 meeting. This meeting is a hearing without a judge, where the trustee asks debtors simple questions regarding their situation and the paperwork they filed. Creditors may also question the debtor, but other than the ayes, none ever show up. And when I was there, the ayes representative always fell asleep, and I'd have to wake her when one of the cases she was there for was called. For the most part, it takes no more than 5 minutes per case. The hearing basically exists for the debtor to affirm under oath that to the best of their knowledge, their paperwork is complete and accurate, and for the trustee to address any issues he has with the case before the case is confirmed and allowed to take its natural course. With few exceptions, an attorney has done all their paperwork for them and is with them, representing them at this hearing. It's all very straightforward and a non-event for the most part. One document that the debtors have to provide lists all their personal property. Another document they provide is used to protect their property, as in bankruptcy, you're still allowed to keep your stuff, your car, and your house, provided the value of these things is within certain limits or meets various criteria. Most people don't have to give up any property at all. However, in a Chapter 7, a trustee can seize any of your property that is not protected. This would be property that is worth more than the values that are allowed, or that is not protected by other factors, such as being exempt from seizure for various reasons provided by the law. The trustee can also seize property if it could be protected, but the debtor has failed to fill out the correct paperwork to create that protection. I'm oversimplifying, but that's the gist of it. But again, very few people lose anything at all. Anyway, in his paperwork, the debtor in this story failed to disclose one item in particular and had also failed to include it in the paperwork that would have protected it. And that is why he was forced to remove the Rolex from his wrist and hand it over to the trustee right then and there. I'm a bankruptcy paralegal. Has anyone ever told you that you write like one too? If you enjoy these videos, please consider subscribing.